Chandran owns several shops in Kuala Lumpur running a retail textiles business. In January 2023, his business was in need of additional capital. His wife, Devi, owns a large house, which was left to her by her father. Devi had previously mentioned to him that she would like to do some sort of business. Recalling this conversation, Chandran persuaded Devi to use her house as security for a loan he is going to negotiate with the bank, in return for which he promised to give her a share in the profits of the business. They visited the bank together, and the bank manager, Alan, who, when informed of Chandran's plan to share his profits with Devi, said,
"I have known Chandran for many years. You would do well to take up his offer, but I would advise you to see your own lawyer before you commit yourself."
As Devi did not have a lawyer of her own, she subsequently had a short private meeting with Chandran's solicitor, who failed to explain the risks involved in using her house as security. Devi then signed the relevant documents charging her house to the bank. After getting the first loan, Chandran realized that his business still needed more capital. He then approached his longtime friend Fuad and persuaded him to provide his shares in a public company as security for another loan from the same bank. Again, he promised a share in the profits of his business to Fuad. Over the years, Fuad had often sought investment advice from Chandran as he felt that Chandran was well versed in business affairs. They visited the bank together, where they met the bank's in-house lawyer, who carefully explained the risks involved to Fuad in Chandran's absence. Fuad then signed the relevant documents charging his shares to the bank to enable Chandran to obtain another loan.
My name is Shafina binti Ibrahim, and I will talk about Devi through Malaysian position. The definition of undue influence is pressure to enter into a contract by the influence of the other. There is no violent act, no one puts guns on the head. It is where someone with a position or authority relationship manipulates you to enter a contract, or induces you to enter into contracts. It is also can be found in Section 16 of the Contracts Act 1950. Section 16 subclauses 1 provided that a contract is said to be induced by one of the parties in a position to dominate the will of other and uses that position to obtain an unfair advantage over the other. Section 16 subclauses 1 sets out the ingredients to establish undue influence. The first limb is whether there is domination of will between Devi and the bank. It is not stated clearly in the facts. However, it can be assumed that Devi had no experience in conducting a business due to the line in the facts she would like to start a business, hence the deduction. Because of this, Devi is more inclined to be influenced by Chandran, who has a lot of experience in business affairs. So, Chandran could potentially be in position where he can have authority over Devi. Moreover, coupled with the bank manager's comment stating that Chandran is trustworthy, and the fact that Chandran's solicitor failed to properly and meticulously advise her, it can safely assume that she had been under influence. The second limb of Section 16 subclauses 1 of Contract Act 1950 is whether there is an unfair advantage between the parties. In the case of Ibrahim bin Musa Bahari bin Nayan, where the plaintiff sought specific performance of an alleged sale and purchase agreement he entered into with Kokshin. The court held that undue influence had not been made out and no unfair advantage obtained. On the facts, both parties have advantages. This can be seen when Devi's husband promised to give her a share in the profits of the business, while Devi persuaded by Chandran to use her house as security for a loan. Therefore, there was no unfair advantage to Devi over the bank. The second requirement of Section 16 subclauses 1 was not proven. Hence, there was no undue influence, and Devi cannot rely on Section 16 subclauses 1 of Contract Act 1950. Next is Section 16 subclauses 2 of Contract Act 1950. This section particularizes the party in a position to dominate the will of another, in which the person who holds real or apparent authority over the other, or the person who stands in a fiduciary relationship to the other, or when the person enters into a contract with a person whose mental capacity is affected by his age or illness or mental distress or bodily distress. For real or apparent part, it is similarly to section 16 subclasses 1 in which the dominant of real part, due to the line in the facts that she would like to start a business, hence the deduction. Because of this, Devi is more inclined to be influenced by Chandran, who has a lot of experience in business affairs. So Chandran could potentially be in a position where he can have authority over Devi. Moreover, coupled with the bank manager's comment stating that Chandran is trustworthy and the fact that Chandran's solicitor failed to properly and meticulously advise her, it can safely assume that she had been unduly influenced. Secondly, is the fiduciary relationship. It might not be considered as a fiduciary relationship because a fiduciary usually stands for trust and confidence and reliance. Lastly, mental capacity. In this case, both parties' mental capacity is not temporarily or permanently affected by the reason of age, illness, or mental or bodily distress, at least not stated in the facts given. According to Section 16, Subclasses 3 of the Contract Act 1950, provided that once a position to dominate the will has been established, the burden of proof then shifts to the person accused of exerting undue influence to prove that he did not do so. This can be applied if Devi can show that Chandran exerted undue influence on him during the application process. The burden of proof will shift to the bank to demonstrate that it exercised due diligence to determine whether any undue influence was exerted by a third party. The remedies for Devi is she has the option to rescind or affirm the contract. I would advise Devi to choose to rescind. The effects of rescission as provided in Section 65 and Section 66 of the Contract Act 1950 apply. Section 65 of Contract Act 1950 provided that when one party rescinds a contract, the other party is excused from further performance, and then rescinding party must restore any benefits received under voidable contract. However, I would highly suggest that Devi should go under Section 66 of the Contract Act 1950, in which provided that when an agreement is discovered to be void or a contract becomes void, any party who received any advantage under the contract must restore any advantage received or make compensation. It is because under Section 66, Devi and the bank who has received any advantage or gained any benefits under a contract that has become void must restore it or make compensation for it to the person from whom he received it. Therefore, both parties to the contract must restore any benefits that he had received from the other. In the earlier referred former federal court case of Yon Mokin and United Malay States Sugar Industries Limited, the architecture fifth progress payment certificate showed that the total value of the work done and the material supplies by the appellant building contractor to respondents amounted to 36,000 K. Thus, the respondents were liable under Section 66 to compensate the said sum of 36,000 K to the appellant building contractors as claimed, irrespective of whether or not the contract were lump sum or entire contracts. In conclusion, the contract will be voidable at Devi's option if the bank cannot demonstrate that it conducted due diligence to determine whether there was any undue influence brought about by a third party. If such were the case, Devi and the bank would both have to make things right or pay back any benefits that were given in exchange. Thank you.
Hello, my name is Amy. I'm the group leader for contract assignment. Today I will covering Devi under English positions. Let's move on to the introductions. Undue influence occurs when a person abuses a position of trust and confidence to pressure another party to enter a legal binding contract against their will. A connection in which one person is dependent on the other is necessary for a judgment of undue influence, the one who is reliant on another. Dependent parties will be coerced into signing a contract that is legally binding and will then be an advantage since the person who is being dependent on will in the admissive positions. The House of Lords, marking ruling in the Royal Bank of Scotland and Ettrick, established the law of undue influence in a definitive manner. There are two kinds of conduct when which undue influence may be concerned. Firstly, an actual undue influence is unlawful to conduct strict censure, which as illegal pressure, coercions, threat, and misrepresentations. Second, presumed undue influence is taking illegitimate advantage of a relationship of trust or vulnerability. Presumed undue influence, which divided into two further subcategories: the Class 2A of presumed undue influence, a pre-existing relationship of special kind. Mere proof of such special relationship give rise to the presumptions of influence, and the Class 2B of presumed undue influence, either a pre-existing relationship of trust and confidence between the parties. If proven, this give rise to the presumptions of undue influence in respect of the transactions sought to be avoided. There are two elements in the presumed undue influence that must be established, as per Lord Nichols said in the Royal Bank of Scotland and Ettrick. Firstly, the complaint repose trust and confidence in the other party, or the other party acquire exceedancy over the complaint. Secondly, the transaction is not weirdly applicable by the relationship of the party or calls for the explanation. In the case of Davy and Bank under English positions, a contract may be avoided where undue influence is exerted on one party to the contract by a third party. First was undue influence by the third party first established. Second, the third party was acting as another party agents, or if the other party had knowledge or constructive notice of the undue influence exerted by the third party. In the case of Barclay Bank and O'Brien, Lord Brown Wilkinson gave some guidelines to the bank to follow. First, warning the sureties not in the presence of principal debtor of the amount of the surety, potential liabilities, and risks involved. Second, advising the surety to take independent legal advice. Furthermore, Lord Nichols provided more guidelines to be followed by the bank when dealing with the surety in the case of Royal Bank of Scotland and Ettrick. First, communicate directly with the surety to see if she wishes to use a solicitor. It can be also the same solicitor as the principal debtor. Second, the bank must provide such a solicitor with full financial information relating to the transaction. Third, if the bank suspects that surety has been misled, the solicitor must be informed of the bank's suspicions. Fourth, the bank will require from the surety solicitor written communications that the nature of the transaction and its practical implications have been fully explained to the surety. White Bank and Bundy was a case where a bank was obligated to provide a guarantee to a customer for his son's debt. The bank secured the guarantee through a mortgage of Bundy House, and the father increased the guarantee and charged based on the bank implicit advice. The Court of Appeal set aside the guarantee and charge, stating that the bank failed to fulfill its trust and confidence relationship with the father, leading to a conflict of interest. Sir Eric Sack clarified to the bank, do not typically incur the duty to provide a guarantee in ordinary circumstances, but in this case, the duty was deemed to have risen and been broken. In Davy's case, the bank didn't follow the guideline as they knew all the consequences. Therefore, Davy can take the initiative and seek rescission of the contract by the court. When rescission is ordered, the whole transaction will be set aside and issue restoring the parties to their original positions. As in the case of TSB Bank and Campfield, the court held that the bank had constructive notice of the third party misrepresentations and ordered rescissions and set aside the whole transactions. Davy didn't know all the facts and circumstances, and the solicitor failed to explain the risks involved in using her house as a security. Thank you.
My name is Sun Anchi. I will be talking about whether Fuad can rescind his contract with the bank from a Malaysian perspective of the law. The first question which arises is whether there was a fiduciary relationship between Chandran and Fuad when a contract between Fuad and the bank was formed. Judges in general see that a fiduciary relationship has a nature which gives rise to a legitimate expectation that the fiduciary will not use his or her position against the principal's interests. It has also been accepted that a fiduciary relationship can be merely a relationship where the one has trust and confidence in the other, and that the latter will act in the best interest of the first. In order for a fiduciary relationship to be established, the person in the position of a potential fiduciary must know that the potential principal is in a vulnerable position and know of the nature of his vulnerability. Since Fuad has been regularly seeking investment advice from Chandran, this is likely to give rise to a relationship of trust and confidence. By Section 16, Article 2 of the Contracts Act 1950, when a party forms a contract with another party to whom he is a fiduciary, the party is considered to be in the position of to dominate the other party's will. The second question is whether there was undue influence by a third party, namely Chandran, in relation to the contract between Fuad and the bank. In the cases of CIBC Mortgages PLC and PIT 1944, one of the parties who entered into a contract received undue influence from a non-party. The other party did not receive constructive notice about the existence of the undue influence at the time when the contract was formed. Hence, the first party could not rescind the contract. Another source states that in order for the advisor to give competent advice to the advisee, the advisor must obtain information from another party with which his advisee is about to enter into a contract. Since Chandran came together with Fuad to the bank's in-house lawyer should have checked if there was possibly any sort of undue influence induced by Chandran or Fuad to contract with the bank. According to Section 16, Article 3 of the Act, firstly, the burden is on the victim to provide sufficient evidence that his transaction with the dominant party is unconscionable. Only if this is proven to be so, the burden shifts to the dominant party to prove that there was no undue influence induced by him. In application, if Fuad can prove that Chandran had induced influence on him, the burden will shift to the bank to prove that they had taken due diligence to figure out whether there was any sort of undue influence induced by a third party. By Section 20 of the Act, where there is undue influence, the contract is voidable at the option of the party whose consent was not free. By Section 65, the party entitled to rescission must restore any benefit that he received from the dominant party back to the dominant party in order to rescind the contract. By Section 66, as how it was interpreted in the case of Yong Mok Hin and United Malay States Sugar Industries 1967, if the agreement shall be rescinded, the dominant party also must restore any benefit he received from the victim back to the victim, or compensate the victim for the benefit. Conclusively, if the bank is not able to prove that they had taken due diligence to find out if there was any undue influence by a third party, the contract will be voidable at Fuad's option. If this were to be the case, both Fuad and the bank must restore or compensate for the benefits exchanged, if any. However, if the bank is able to prove otherwise, then Fuad will not be able to rescind the contract.
Hello, my name is Samantha and I'll be covering the case of Fuad and bank. So it may initially seem as though Fuad had a claim for 2B, Class 2B of alleged undue influence. It should be established first and foremost that Fuad had consented to use his shares in a public company as security for Chandran's loan in exchange for a percentage of the company's profits. The agreement between Fuad and Chandran is obviously one of mutual benefit, as Fuad's ability to assert that he is a victim of undue influence is therefore less likely, given that he also obtained independent legal advice from the bank's attorney, who meticulously highlighted the transaction's risk to him. This alone demonstrates that the bank acted responsibly. In addition, although undue influence frequently entails one party in a position to dominate or manipulate the innocent party, there is proof that Fuad obtained appropriate legal advice in this instance. Fuad's claim that he was ignorant of the implications of the deal may now be more difficult and complicated to make. Although Fuad argued that his claim met the criteria of a claim under Class 2B of presumed influence because he had placed a great deal of trust and confidence in Chandran, especially in financial matters, and frequently asked for investment advice because he believed that Chandran was knowledgeable about business affairs. This transaction, nevertheless, does not warrant in any way an explanation on the dominant party. Fuad is able to establish that there was an influence in this situation, but he is unable to demonstrate that it was excessive. Even if Fuad was successful in establishing a presumption of undue influence, Chandra will be able to rebut the assumption by demonstrating that Fuad had signed the contract voluntarily. The presumption will be overturned according to Tritell's law of contract if the party benefiting from the transaction demonstrates that the transaction was the free exercise of independent will by applying the case of Royal Bank of Scotland and Estridge No. 2. Chandra will be able to demonstrate that Fuad had impartial advice from the bank, which may be regarded as a third party, before engaging in the transaction. Fuad should also be advised to inquire into the concept of promissory estoppel at the same time. Promissory estoppel may be an applicable principle of law given that Chandran guaranteed Fuad a portion of the business profits in exchange for the security, and Fuad relied on that promise to his detriment. This generally takes place when a clear promise and reliance exists. As a result, it may not be enough to terminate the contract. Furthermore, it is not stated why Fuad regrets entering the contract. If it was Chandran's failure to keep his end of the transaction was the cause, Fuad should assert his claim for a breach of contract rather than undue influence. More evidence is to be gathered in order to further assert Fuad's position in this circumstance. However, it appears that overall the business relationship between Fuad and Chandran is just a bad investment on Fuad's part. Although not stated in facts given, it could be assumed that before Fuad even considered using his shares as security, he would have wanted to know the details of Chandran's business, like Chandran's annual income, his turnover, inventory turnover, and so on. After he had asked all of the relevant questions and had advice from the bank, Fuad most likely thought that it was a good investment at that time. And he also had faith in Chandran's insight to business as well. Taking in the year all of this had happened, it was the year that the world's economy was just starting to pick up. Hence, in order to boost his business revenue, Chandran had to find ways to pump in more capital. Moreover, in the world of business, there is always a percentage of risk involved. So in this case, it was a business investment gone bad. If Fuad really wanted to get the value of his shares back, it should be inquired whether there was any agreement between Chandran and him that stated that even if the investment were to go bad, Chandran still has to pay him back. If there was none, then it would be very hard for Fuad to set aside the contract. However, it would seem unlikely. Thank you.
In conclusion, in Devi's circumstances, she would most likely be able to receive or set aside the contract based on the facts and elaboration given in under both the Malaysian position and the English position. In Fuad's situation, however, it is very unlikely that he will be successful in his claim for undue influence. It is imperative to note that more facts and evidence is needed to fully ascertain both of their standing in both of their respective contracts. That is all from our group today. Thank you.